All right, a very good morning to everyone. The Second Region Child Protection Court number 1, Liberty County, is now in session. We have one matter on our docket this morning for pretrial and assorted motions. I see Mr. Hurst and Mr. Buck, Ms. Colombo. I understand.
Judge, might I make an announcement?
Yes, you may. My understanding is maybe we have a couple of attorneys tied up in Montgomery County, but
And I've got a temporary order hearing across the street real quick, but I don't have any pretrial. And my understanding is Mr. Downing has pulled his motion to strike. He passed it. As a result, my motion for leave is probably moot because we're now past the 7 days. So I don't think there's any other matters for me to take up with the court this morning.
Okay, all right, Mr. Hurst. Thank you. And before you go,
Yes,
Ms. Colombo, can you hear me? Did you hear Mr. Hurst? Mr. Hurst represents the intervenors.
Yes, I can hear you, Judge, and I heard Mr. Hurst.
Okay, very good. So, Mr. Buck, do you know whether, I believe Ms. Iverson is tied up in Montgomery County with a couple of hearings at 9. Maybe Mr. Downing is as well?
I believe that's the case. I texted him earlier this morning and I have not heard back.
Okay. Why don't we do this? If there's a strenuous objection, let me know. Why don't we recess until 10 and check back at 10 o'clock. Mr. Hurst, if you're not able to do that, we'll certainly let you know if anything of import comes up.
Judge, I appreciate it. Thank you. May I be excused?
You may. And so, Ms. Colombo, are you okay with that? Mr. Buck, are you okay with that?
No objection, Judge.
Okay, very
No
good. So
objection,
we'll be in recess until 10. And one of the preliminary questions I'll be posing to you, Mr. Buck, is whether or not you and your client will be participating in the jury trial. So you can hold your answer, and we'll be in recess until 10 a.m. If you all can pass the word to Mr. Downing and Ms. Iverson, please. All right. Thank you all very much.
Thank you, Judge.
Thank you, Judge.
Thank you. Are we still waiting on Montgomery County and Mr. Downing and Ms. Iverson? Okay, Ms. Adams, I'm not able to hear you. Let me see if it's on my end.
Yes, sir, Judge. This is Williams. I'm texting Ms. Iverson now. I know she did text me about 20 minutes ago and said the judge just got on the bench, so I'm following up right now.
Okay, thank you. And Ms. Adams, may I see if I can hear you this time? Ms. Adams, good morning. Okay, Ms. Adams, I don't know if you can hear us, but I cannot hear you. All right, I believe she must have logged off to reconnect. All right, and we have Mr. Buck back. Yes? Mr. Buck, can you hear me?
Here, Judge.
Okay, very good. Thank you. Mr. Buck, do you happen to know anything about your colleagues ETA from Montgomery County?
I do not, but I can send a text real quick.
Okay, well, I think they're being bombarded probably right now. Okay, let's try it, Ms. Adams.
I can hear you. I'm so sorry about that, Judge.
Not at all. So as you can probably see, we have Mr. Hurst, we have Mr. Buck, still waiting on Mr. Downing and Ms. Iverson. I believe they are at a docket in Montgomery County. All right, I believe we have Ms. Iverson. Is that correct, Ms. Iverson? Can you hear me?
Yes, sir. And
Okay.
I've only have one hearing down. I've got one to go, but I have permission to step out.
Okay, all right, thank you. And I believe we're still waiting on Mr. Downing.
Good morning, Judge. This is Macy Edwards. I did reach out to Mr. Downing and I have not received a response yet, so I will let you know if I hear from him.
All right, very good. Thank you so much, Ms. Edwards. All right, so continuing to hold. I'm guessing he might be there in Montgomery County as well, Ms. Iverson.
He's not in the courtroom I'm in, Judge.
Okay, all right.
I'm texting him as well, see what he says.
Okay. Thank you.
Sure.
Judge, how many issues are you taking up today?
Well, the motion to strike and a motion for leave to amend pleadings, any and all pretrial matters that are outstanding. And my understanding from Mr. Hurst earlier was that he believed that Mr. Downing was passing his motion to strike. And so as a consequence, Mr. Hurst believed his would be moved. So that's kind of where we are.
That's what
pretty
Mr.
good. I
Downing
got
said
an
in an
email.
email yesterday. Right.
Okay, here's Mr. Downing. And I didn't hear you. Somebody, there was background noise, Ms. Iverson. I believe you said something about an email from Mr. Downing. And I believe we have.
Yes, sir, but if he's
Yes,
here,
Judge,
I'll
I'm
let him
here.
speak for himself. Yeah.
Okay, we have Mr. Downing. So I think we have everyone, at least for the moment. So let's strike while the proverbial iron is hot. Calls number, we're on the record. F for a pretrial and assorted motions if necessary. Mr. Downing, I'll start announcements with you.
Your Honor, we are agreeing to pass both of our motions to strike at this time. Both their standing and the motion to strike their most recent amended pleading.
All right, any objections to that? Anything further on that announcement from anyone? All right, with that, the court will consider Mr. Downing's motions passed. And Mr. Hurst, updated announcements from you, if any.
Judge, I don't have any additional pretrial, and I think my motion for leave is moot now because since we got past the 6-day mark, it's now 9 days, or 8 days. So I don't think I need it. So I'll just pass that one as well. I don't have any additional pretrial after that.
All right. So the same as to Mr. Hurst's motion or motions. We are set to begin a jury trial this coming Wednesday. I think you all know by now that obviously I hope that it's going to be in person, that it will be at the Justice of the Peace #1, which is located at 2103 Coss Street in Liberty, Texas. So some housekeeping and arrangements, logistics will have to be made to seat the 12-person jury. I generally will choose 2 alternates, so 14. So any announcements up to this point, Ms. Adams, Ms. Iverson? Mr. Buck?
Not at this point.
Okay, thank you. Mr. Buck, will you and your client be taking part in the jury trial?
With the MSA, Judge, we do not intend to. And I would ask to be excused, given my client has no contested issue.
All right, and has your client executed and filed an affidavit of voluntary relinquishment?
He has not. There's an MSA that's been filed where the parties have agreed to terminate his parental rights based on O grounds only. He has a relinquishment, and I believe he'd be willing to sign it if we needed to go that route.
There are some reasons that I was made aware of yesterday. It would be very beneficial if he would sign the relinquishment and return that rather than going on the O grounds. And if you wanted to discuss that later, I'd be happy to do so.
Okay. I agree with you. It's a logistical challenge for him. That's the main problem, but I think he may be able to try to get it done.
Okay.
Okay. Well, if I would be inclined to consider releasing you upon the filing of his affidavit of relinquishment after review by the court.
Understand. If that does not occur, what would the court like me to do in terms of appearance for a jury trial?
Appear.
Okay. I will
In person, that is.
I will do my best to get him to sign that, get that affidavit sent over.
Okay, all right. Thank
Judge,
you.
this may
Yes.
be out of my lane, but you're used to that. Would the court be willing to potentially reimburse the father's attorney if he needed to hire a mobile notary?
I absolutely would.
Okay, I'm just trying to throw out
Yeah.
alternatives. I've been made aware of the situations that father has some time issues, but I know they exist.
Yeah.
I have not been able to locate one in the department, and I have tried. But anyway, so that's another idea.
Yeah, I have had mixed reviews, but should he be able to do that, I absolutely would.
Thank you, Your Honor.
Yeah, thank you for that. That was helpful. So, Mr. Buck, certainly remember that or know that. Okay, was any discovery conducted in this case, attorneys?
Yes, Your Honor, I conducted discovery.
All right. Are there any outstanding issues regarding your discovery?
I don't believe so.
Okay, you got everything you need. Everybody's going to be ready to go.
Yes, Your Honor.
Okay, very good.
I did file some limines. If we wanted to go over those, I'm going to go over those on the 23rd.
Okay. How many are there? I have not seen them yet. How many are there?
25.
25. Okay. So,
And we agree to 15.
okay.
I know you would be happy to hear that.
Yes. Well, it makes a little more plausible getting anything done today. I think so Ms. Adams, do you care? Want to make sure everybody is listening and can hear. See if you agree with Ms. Adams. Ms. Adams, do you care to give Mr. Downing the numbers, give the court the numbers?
That we agree to?
Yes, ma'am.
Yes, of course. Actually, I have written down the ones we don't agree to. Give me just a second. Let me get to the different page.
Or we can do it that way.
I can give you the ones that we would like to discuss.
Okay, so
if that's
whatever's
okay.
easiest, you may do that.
Great.
Mr. Downing, none of these has been amended, right? So we know that we're looking at the same filing.
Yes, Your Honor.
Okay,
that is
very
correct.
good. Okay, so Ms. Adams, you may proceed with the numbers that you want to discuss.
4, 9.
Name of the CAC room? I do not know.
Okay, 4, 9, 12,
Mm-hmm.
15,
Mhm.
16,
Mm-hmm.
17, 20, 23, 24, and 25.
Okay. Let me read those back, make sure that I got them, Mr. Downing and the others can make sure they got them. So they are numbers 4, 9, 12, 15, 16, 17, 20, 23, 24, 25. And
Yes, I'm sorry, that is my list.
okay, and that comes to 10. So all right, so let's do a few other housekeeping matters and see what, if any, time we have for to take up the disputed motions in limine. So in terms of the time for voir dire, I would be inclined to give the department 30 minutes. Mr. Downing, 30 minutes. Mr. Buck, 30 minutes if needed, and 15 minutes to the intervenors, 15 minutes to Ms. Iverson.
Your Honor, I
The
don't believe
department.
time for the department. We were going to request an hour. We could probably settle. I mean, we would 45 minutes would be more workable, with a possible extension if necessary.
Okay. All right, so I'll do 45 minutes. You all obviously bear the burden, so 45 minutes for the department.
Yes.
What it's worth, Your Honor, the department and I are aligned.
Okay. Well, perhaps should Ms. Adams need a little more time, maybe she can borrow it from your 15 minutes.
Sure.
It'll
You
be
probably have to keep it instead of borrowing.
and it will be Natalie. Natalie will be doing the voir dire.
Okay, Ms. Colombo. Okay, very good. And before we get to strikes, let me discuss the time allotment for opening statements. Ms. Adams, you're requesting how much time for opening statements?
That's also a question for Ms. Colombo.
Okay, Ms. Colombo.
Yes, Judge, sorry about that, trying to unmute myself. I don't believe I need any more than 10 minutes.
All right, thank you. And Mr. Downing?
Your Honor, 10 minutes I think would be adequate.
Okay, thank you. Mr. Buck?
Uh, 5 minutes at most, Judge.
Okay. And Mr. Hurst?
Probably 5 to 10 minutes, Judge. Nothing more than that.
All right. And thank you, Ms. Iverson.
5 to 10 will be plenty.
Okay. I believe I heard 5 to 10 would be plenty. Is that right?
Yes, sir.
Okay. All right. Thank you. So I have for the department 10 minutes, Mr. Downing 10 minutes for the mother, Mr. Buck 5 minutes for the father, Mr. Hurst 5 to 10 for the intervenors, and Ms. Iverson 5 to 10 for the child. So the court will approve that. And in terms of the ledger and the scorecard, it appears that the department, the intervenors, and Ms. Iverson are all aligned, that Mr. Buck and Mr. Cox are arguably aligned. So are you all okay with both sides sharing 6 strikes each, or do we need to discuss that?
I would agree with that.
Yeah, Judge, interveners are okay with that as well.
The department can agree.
Okay, thank you. And let's see, I believe that leaves Mr. Downing.
I agree with them being aligned and sharing strikes, Your Honor.
Okay, all right. So 6 strikes per side. And you all correct me if there's something else, but I believe that only leaves motions in limine. The court will, I'm sure that you all are hammering out a jury charge. Maybe somebody already has one that fits the pattern of the case. So I'll receive that upon our first lunch break. And I do want to break right at noon every day. And depending on what the logistics and the lunch plans are for the jury, I'll try to give us an hour. We may need to go an hour and a half. We're going to go every day at least until 4:35 if the court is open. And I plan on trying to take breaks about every hour and a half for the jury and you all. Now, if anything else other than the motions in limine.
Your Honor, I do have one additional issue, if I may, really quickly.
You may.
The department has one expert witness that needs to testify virtually due to his professional schedule. Will the court allow virtual testimony of an expert witness?
I will if it's agreed and if the technology is there. So let me see. I'm assuming, but I don't want to, that Mr. Downing and everyone else knows whom you're speaking of.
I do not, Your
Yes,
Honor.
they should. It was a provider of the mother, so it should not be a surprise, and it was on our witness list that has been on file.
I don't know who they're asking to testify remotely, though.
And
Joseph
what is,
Brown.
well, pardon me?
Who?
Joseph Brown.
Okay, and so he's a therapist.
Yes.
So right now, I don't have authority to agree to that, but I can talk to my client, and I will let the department know as soon as I get a response from my client. But I should let them know early next week whether or not we can agree to it.
Okay. All right. And when do you have him scheduled, Ms. Edwards?
Friday, Your Honor.
Okay. Do you have a time?
He said he could make himself available the entire day on Friday.
Okay. I do know that Mr. Brown is a provider in several of my counties, but I don't recall right now where his office is. Can you refresh my memory, Ms. Edwards?
Yes, Judge. Give me one. He's located in Humble.
Okay. Okay, if you all will cannot come to an agreement, just let my coordinator know, and we will take that up certainly before Friday.
Thank you, Judge.
If there's not an agreement and if the court does not allow his virtual testimony, and I'm not saying here and now that I won't, but if I don't, I would be more than amenable to trying to do our best to accommodate his schedule, even taking him out of order at a set time, Friday, the 25th.
And
Thank you,
Judge.
Judge. I'll get with him for a specific time
All
to
right.
have.
Thank you.
And Judge, I just want to make sure my calendar's right. I have us starting on Wednesday the 23rd at 9. Is there a time that you would like us to be at the court?
Yeah, so 8:30, but you're right. It's a Wednesday start.
Okay.
And again, it's over maybe 2 or 3 blocks from the main courthouse in JP number 1 at 2103 Cos Street, COS Street.
Thank you very much.
And it's very close confines. All right. Anything else before addressing Mr. Downing's motions in limine? All right. Hearing nothing, and again, if you have any questions or something comes up, please let my coordinator know. If there is some delay in response, go ahead and email me directly and copying all of the attorneys, please. All right, so let's go to Mr. Downing's motions in limine, and I believe number 4.
Oh, Judge, do you have a copy? Or do
I,
you want me to read it to you?
that's what I'm looking for.
Okay, just
How long is it?
1, 2, 3, 4, 5 lines.
5
long.
lines.
I mean, where are you talking? You mean how long is this number 4 or the
Yeah,
whole thing?
that's what I meant. How long is how much reading would you have to do?
No, I don't mind. It says photographs and visual aids showing any document. Okay, photographs and visual aids, period. Showing any documents, photographs, or visual aids to the jury or displaying them so that any jury member can see them unless and until they have been tendered to the opposing counsel and have been admitted into evidence or approved for admission or use before the jury, either by the court or by the counsel. I don't believe that's appropriate. If we have photographs or visual aids, we should be able to use them. There's no reason there is no reason for this.
Your Honor, this is photographs that have not been admitted as evidence. And so they shouldn't be allowed to parade around a photograph where the jury can catch a glimpse of it before it's been admitted.
I disagree. If we have a picture of the child that we want to use in the opening, we can have every right to use that picture. If we have a visual aid where there's a chart that explains what, I'm not saying we have this, I'm just, but we have clear and convincing evidence, we can use visual aids and photographs. If they're not entered into evidence, and this is only photographs and visual aids. We're not talking about evidence. We're not talking about things that would necessarily go back to the jury room. But this is very commonplace, and I don't believe that the department should be tied into not being able to use photographs and visual aids.
All right. So the court is going to grant the request for limine number 4, and I will say, within the parameters Ms. Adams described, I'm likely to allow it, but I am going to require you all to approach first. And I'll inquire into whether or not I think there might be any prejudice or the like. So I'm going to grant it, but of course, this only means that you all need to approach first. All right, number 9.
9 is opinion, and I can stop reading if you ever find it, Judge, but just I'll read it until then. Opinion of credibility, any argument or expression of counsel's opinion regarding the credibility of any witness or party except during closing argument.
Okay, Mr. Downing, any response?
And Your Honor, it says except closing arguments. So I think it's have an argumentative type question, or for the lawyer to give their opinion during the evidence portion of the case. It's not appropriate for me to weigh the credibility, or for opposing counsel to weigh the credibility of a witness in testimony. In the closing argument, I get it. But not in the evidence, not in front of the jury.
And I believe that if I'm not saying that the counsel's argument, I guess it's the way that it's written, any argument or expression of counsel's opinion. So you can't ask certain questions. You can't make, I feel like if anything that was against the rules of evidence comes in, then Mr. Downing could object. If something is beyond the line of counsel's opinion or counsel's counsel's testifying, that would be fine. But I just don't see this as a motion to limine. It's pretty broad, or it could be interpreted very broadly. And I don't want to break it. So,
all right. Any final response, Mr. Downing?
And Your Honor, this isn't talking about eliciting testimony that would hurt credibility. What this is talking about is this is eliciting or asking a question in such a way where counsel is giving their opinion as to the credibility of the witness. I think that's appropriate in closing, but not appropriate in when asking a question.
and Mr. Downing's response actually cements my fact. It's about the way we're asking questions, and I don't think we should be limited in the way that we ask questions.
And Your Honor, that's what limines are for. They are to limit in how we ask questions, to do it appropriately in front of the jury.
I would disagree with that it's not the way in which we ask questions. It would be matters to be brought up or not brought up. But I've never heard of attorneys' structuring of their questions being controlled like that.
All right. So all right. Thank you, Ms. Iverson. So number 9 is denied, and the court will consider any legal objections if and when a question of that sort is asked. Number 12.
And this is just a modification. Any reference? Wait, no, I'm sorry. Let me go. Wait.
And still reading. Thank you, Ms. Adams.
Yes. Give me a second.
12 states any reference to any statements by a counselor, therapist, or physician who have not been designated as a witness.
Okay, as long as that's in the department's witness list, we're fine. If that's what you mean by designated as a witness,
in their witness list or disclosures?
In either or, yes.
Okay.
Well, no, they have to be disclosed and on the witness list, so they'd have to be in your response to request for disclosures as well.
Okay, that's a completely different question that we might need to address.
Okay, if you wouldn't mind, one of you read it to me, please.
Any reference
I can read it.
to any statement by any counselor, therapist, or physician who have not been designated as a witness. Judge, the argument is the department did respond to the disclosures early in the case, and we also created a witness list later in the case that designated certain individuals as witnesses that were not previously disclosed in the disclosures.
Okay, and is there a difference? It sounds like there is a difference of those on your witness list and those who have been disclosed as potential witnesses. Is that the case?
That is the case, yes. By creating the witness list and sharing it with counsel, the department intended to notify the all the parties of who the witnesses would be in that manner.
Okay, anything further, Mr. Downing?
And Your Honor, I don't have their witness list sitting in front of me, but so long as it is compliant as a request for disclosure would be, in that they provide all the necessary information, I would not object to that witness being called.
Okay, is there anyone on the witness list, Ms. Adams, who is not on the witness list by way of the disclosures?
Yes. I think I'm answering your question. I think we're specifically talking, and I think you're going to have to ask Miss Edwards because she's more finely
Sure.
with the case as to who is. I know that we have at least one person that is on the witness list that was not on the disclosures, which we gave early in the case.
Okay. And when was Ms. Edwards, when was the witness list filed, if you have that at hand?
I don't have the exact date, Your Honor, but it was well over 30 days prior to trial.
Okay.
And Your Honor, I just have to say, like, I don't have it in front of me, but if it has the name, address, phone number, and description of what they can testify about, that would comply with a request for disclosure, then I would not object to them being a fact witness. I may object to them being an expert witness if they weren't disclosed as such.
If I may, Judge.
You may.
The witness list does identify them as an expert witness and their connection to the case, as well as all contact information.
All right, the ruling of the court is for those statements of someone who is not on the witness list with their role, their address, and their contact information. The court is going to require that you all approach before using any of those. And that's as to number 12. All right, number 15.
I'm sorry, Judge, I might have missed it. What did you say again? It was as far as the disclosures of the witness list?
So for those statements of someone who is not on the witness list, but maybe on the disclosures, and provided that they're on the witness list in terms of their address, their role, their contact information, if any other statements other than those are attempted to be elicited or offered, then the court is going to require that you all approach prior to that.
And maybe everyone else understands, but I'm still a little confused, Judge. The one particular witness that we're discussing, you want us to approach before anything that he has to say is offered, or if he's either on the witness list or on the disclosure list, it's okay?
If he's not properly and fully on the witness list,
Okay.
he must approach.
Okay, great.
He or
Thank
she, whatever.
So we need to have a conversation with Mr. Downing to see if there's a problem after he's looked at the witness list. Got it. Great. Thank you.
Thank you. Number 15.
Any witness testimony from a witness called by any party who was not disclosed in the party's pretrial disclosures. There are no, I don't know if we're talking about just the disclosures requested by Mr. Downing early in the case. There are no pretrial disclosures under the Texas Rules of Procedure in regard to family law cases anymore.
I agree with you. I meant in your response in the party's response to request for disclosures. I pulled that from an old form when there were pretrial disclosures.
Okay, so we had this. So this is all basically the same answer
And
as 12.
I would,
Judge's answer is going to be the same as whatever the answer is to number 12.
That's correct.
Okay.
Okay.
Are you good with that, Mr. Downing, or do you need more clarification before I move on?
I'm good with that.
Okay. Any attempt to introduce any attempt to introduce an exhibit that was not disclosed to the parties pretrial disclosure, same thing.
I'll withdraw 16.
Okay.
There aren't pretrial disclosures, so with 16 is withdrawn.
All right, 16 is withdrawn. Number 17.
17 is that any reference to the voluntary relinquishment of the parental rights or agreement to terminate parental rights of Ronnie Cox. The only problem the department has with that, it kind of depends on where we are at the beginning of this case. And I don't know what Mr. Downey, because we might have to have the jury, we might have to give it to the jury for the jury to terminate the dad's rights. I mean, it's a possibility. So I guess this is, but we're not going to use that against Mr. Downing's client. So I guess we need more to understand what Mr. Downing wants from that.
And Your Honor, I'd say that the prejudice outweighs the probative value of the jury knowing that he's voluntarily relinquishing his rights. As the mom, they might think, well, dad's relinquished, we should terminate mom just because of that fact. And so I don't think it's relevant. I think the fact that there's a mediated settlement agreement that Ronnie Cox has agreed to terminate his rights takes it out of being a fact issue and makes it a legal issue for the court to decide. The only issue, I don't see an issue for the jury there to decide, and so I think it would be improper to present that evidence to the jury, and all that would work to do would be prejudice Miss Strickland.
And I think we're on the same wavelength. But it depends on if we need if we need the jury to terminate his rights, we will need to give this information to the jury. But there's no intent to just put it up in front of the court as to make it prejudicial. I understand the prejudicial argument. That's not the intent, but we might have to, based on if we get the relinquishment or not, based on if we are able to terminate without the jury prior to the trial.
All right, number 17 is hereby denied. And the court will certainly field any objection as to prejudice if and when that occurs. All right, number 20.
Any reference to the terms of the temporary orders? I don't know what that means.
Your Honor, I don't think they can reference a prior order of this court in the jury trial. It will show what weight the court has given to it, and I believe it's improper to bring the temporary orders up in the final trial in front of the jury.
Okay, all right, thank you. Response, if any, Ms. Adams, Ms. Edwards?
I don't necessarily have a response. I think that that's reasonable for the department to be able to do that.
And Your Honor, if I may as well.
You may.
I believe it's necessary to reference, at least in part, the court's orders of potentially a family plan of service if we're going to pursue O grounds. And it would be hugely prejudicial to the department if we can't get it into evidence that it was in fact a court order that was violated by Ms. Strickland.
And Your Honor, the family plan of service that is not a temporary order. The temporary order is the order after the adversary hearing, where it names the department as the temporary conservator over the child. And I think it is extremely prejudicial to have that as an exhibit or to present that to the jury that the department was placed as a temporary managing conservator over the child in the termination suit.
Well, isn't that basically one of the elements that's subsumed under O? That it arises from a case of abuse or neglect?
And Your Honor, the fact that the case is for termination shows that it's a case for abuse and neglect. So I think it's improper to show the weight the judge has given the evidence or the court's comment on an evidence in front of the jury.
Okay, do you have any authority for that, Mr. Downing?
You will bear with me, Your Honor.
Of course. And while you're doing that, Mr. Downing, Ms. Adams, are we on number 20 or 23?
That was 20. So we
Okay.
just have 23, 24, and 25.
Okay, so we're still on number 20.
Yes.
All right, very good. And in number 20, is the language for temporary orders, is that in the plural?
It is in the plural. It's lowercase. Temporary orders is lowercase and orders
Okay.
is plural.
Judge, I've been ordered to be back inside the courtroom at 10 after 11.
Yes, Your Honor. I'm not finding the authority right now, but I know at the very least the findings should be redacted out.
Okay, so I'm
Because that's the court's comment on the weight of the evidence.
bear with me. All right, I'm gonna provisionally grant number 20. Number 23.
It's similar, Judge. Any reference to or comment on findings by the court on any orders. It's very difficult for the department to not reference things that happened in the case for the pendency of this case. And it would greatly hinder explaining the case to the jury of what occurs and what occurred in this case. I don't know if Mr. Downing specifically a specific ruling that he's talking about that is prejudicial or just that it occurred.
And Your Honor, this is not talking about rulings. This is talking about findings of the court. That's different.
So I'm going to provisionally grant number 23, give Mr. Downing time to come up with authority on that. But obviously that does not foreclose the issue, but I'm going to provisionally grant it, just merely requiring you all to approach first.
Oh,
All right,
wait,
number 24.
I was told 11:10.
All right, so we got 4 minutes. 24.
Any reference to hearsay statements made by the children, and clearly the department doesn't want to elicit any statements that are not authorized by the law to get them in, but there are ways to get in statements of the children that are within the law. So I'm a little confused about this question as well.
Okay. All right, so I'm going to deny number 24. Certainly these have to be admissible, some sort of exception or statute showing that they're not in fact actually hearsay. So number 24 is denied. Finally, number 23.
This one is long. Any recommendation.
25. I might have said 23. I'm sorry. Go ahead.
That's fine. Any recommendation regarding custody or possession or access from any non-party who has not conducted a custody evaluation or is not qualified to conduct a custody evaluation. Texas Family Code 104.008A provides that, quote, a person may not offer an expert opinion or recommendation relating to the conservatorship or possession of or access to a child at issue in a suit unless the person has conducted a child custody evaluation relating to the child under subchapter D, chapter 107, end quote. Texas Family Code 104.008A. See also in Ray, GOPALAN. There's a site, Westlaw site. It was in 2020 out of Texas Appellate Austin, July 15th, 2021, original proceeding. And then a open those were quote parentheses, broadly determining that any opinion relating to custody, and relating was italicized, relating to custody, possession, or access is precluded by the statute.
Okay. Well, CASA will make similar recommendations. They're not expert witnesses, but the child custody evaluations, generally those are not our cases. So has one even been done?
No, I think the limit is that from a non-party who has not conducted. So it's saying that no one can opine as to what the custody or possession or access should be.
As an expert?
As an expert, yes, Your Honor.
Okay, that doesn't say that here.
Okay.
Well, they have to be qualified as well. I mean, if they're a fact witness, they can't opine.
I believe that they can.
Well, I'm gonna grant number 25. Y'all can approach if at all.
And that's it.
Anything else? Okay. All right. So it is 11:10. So I wish you all very, very well. If something comes up, please let my coordinator, Ms. Wallingford, and or me know. And is there anything else from anyone else before we adjourn and excuse you?
No, Your
Thanks
Honor.
to everyone, and apologies for working around my hectic schedule this morning. I really appreciate it.
My apologies as well for being tardy.
Not at all. Not at all. Tell Judge Tucker or whomever hello. Thank you all. All right.
Thank you,
Anything else
Judge.
from the department?
No, Your Honor. That's all. Thank you.
Okay, everybody, please take care. You are excused.
Thank you.
Have a wonderful weekend.
Bye.
Let's see. I believe we have everyone, don't we? We may need.
I think Mr. McCatherine is moving offices today.
And in his defense, we did have a discussion yesterday about possibly resetting this case. And I think he thought that, well, I know for a fact he thought it was for sure going to be reset.
And that's why the caretakers aren't here. So normally they're here.
Okay, do you all have a proposed date to which to reset this status hearing? It's been pending a minute.
It has. We have discussed the 13th. I think that's our next normal court docket, and we're all available then. We also
go ahead.
I was saying, I think as to the father's service plan, we have an agreement we can proceed on today, or we can just wait till we're all together. It's up to the court.
If the question were put to him, did Mr. McCatherine voice any objections to doing Dad's piece today?
I didn't put that question to him. I'm sorry. It was
Okay.
kind of a last minute idea.
Now, if somebody would shoot him a quick email, not email, a text, and I understand if he's moving, he's may not even be able to answer that, but let's give it a try. So I'm admitting your client into the virtual courtroom, Ms. Moore.
Thank you.
Yeah, we, as you all know, we would have time to do it on May the 13th.
And also, Judge, I know that Ms. Bythewood has some prior engagements today, as do I. So we were hoping, as to the father, we could do an agreed status, just kind of put on the record what the services that we've agreed to are, and handle it that way if the court's amenable to that.
Okay, I am, and is Ms. Bythewood willing to go forward with that without the caregivers?
I heard my name. I apologize.
Okay, so if you'll repeat your statement, Ms. Moore.
Oh, Amy, I was just letting him know that we had an agreement to do an agreed status and just kind of put the agreement and the services on the record for the sake of time.
Right. I have to do a proclamation. It's the National Day of Prayer, as everyone here I know knows. But Mr. McCatherine said that he had no objection to going forward with Dad.
Okay. All right. So are you okay going forward with Dad's portion without the caregivers here? I do want just an update on where PB is and how she's doing.
Yeah, she's with maternal grandmother and step grandfather, and she's doing great.
Okay, so good. That continues to be the case. That's excellent. So, all right. Okay, so either Ms. Zalesniak or Ms. Moore, are you okay, Mr. Crocker, with everything so far? Mr. Crocker?
He looks frozen.
I'm glad he's frozen because I just thought he was so unhappy with us.
He looks very stoic.
Well, hopefully y'all, not me, but who knows?
Oh, it's us.
Okay, so Ms. Zalesniak and or Ms. Moore, if you all want to proffer, the court will note, Mr. Bell, if you can unmute and simply announce your appearance, Robert Bell.
Robert Bell.
All right, thank you. Okay, you can go back to mute, Mr. Bell. Thank you. I have you marked present. Right. So again, either Ms. Zalesniak and or Ms. Moore, you all may proffer.
Lori, you okay if I just start reading things and then you can jump in if you need to?
I would prefer, yes.
Okay. So we were going to have Mr. Bell complete let me, I guess, tell the court there's been a service plan filed in this case. We're agreeing to file a new service plan, an amended one that includes all these changes that I'm about to delineate for the court.
Okay.
So it would be for a network approved parenting class that he would follow and adhere to all the recommendations provided by the course instructor and complete the course and provide the certificate of completion. Mr. Bell's address has recently been acquired by the network, so we'll be able to pick out a particular parenting course for him to attend. The current service plan that's on file with the court doesn't have a resource listed because we were unsure initially of where he was located. But now that we have that, we'll be able to update that portion of the plan. As far as substance abuse, he will complete an initial hair follicle and urinalysis testing. If those are positive, then he'll have to do an assessment and follow the recommendations of that assessment. So outpatient rehab that's in that current service plan won't be a requirement unless there's a positive drug test and a recommendation from the assessment.
Okay, positive on both or either?
Either.
Okay.
But wait, just to be clear, you're saying if he's positive on either, do an ADAC and follow the recommendations of ADAC.
Yes.
Okay.
He will complete. It's got it in here as a mental health assessment, but a psychological, and follow the recommendations of the psychological. Along with that, he will sign a release of information for any of the assessments that he's doing as a condition of his service plan, so that we can obtain the results of those assessments.
And we agree not to use Dr. Amin for the psychological.
Yes, and we agreed not to use Dr. Amin for the psych. Identify a positive social support system. And I think that was everything. Did I miss something?
Yes. Got it.
And you had asked, Judge, for an update on ICWA. I think the plan is to get with Mr. Bell and see what he knows about his or biological parents, so that we can obtain their names and proceed with ICWA that way.
And I can take the fall for that, Judge, because quite frankly, I completely forgot about that until I just heard Tatiana remind me. So I will certainly get with him and get that information.
Okay. All right. Well, I don't know what the punishment for that is, so we'll just have to see. But
just let it run concurrently with all my other punishments, please.
Okay. Well, it's compounding. So Mr. Bell will not have to be. Mr. Bell will not have to be present on the 13th, but I will receive an update on ICWA, if any, as to his side of the house on the 13th. But he may be present, but he won't have to be on the 13th. Okay, very good. Okay, anything else, Ms. Botwood, Mr. Crocker, anybody, anything else on the father of Mr. Bell's service plan as amended to be filed?
Right.
And I don't believe that there's a current visitation plan in place or needs to be. I believe that Mr. Bell can send things to the case manager to hold on to until the child is ready to receive it.
Okay, let me make note of that. Bear with me just a moment. Right, and so that would be send anything to the case manager and or the supervisor, not placement.
Correct. And the child will has asked that the case manager, she'll let her know. She doesn't want to be told. She'll let her know. And I got a ICWA question. Because there hasn't been a possibility of Native American ancestry, there's the I was adopted, I'm not sure. Does that even trigger ICWA at this point?
Well, assuming you wouldn't ask a question you don't know the answer to, we're going to do the belt and suspenders approach until further notice. So I'll receive any information, if any, on the 13th. But yeah, that great point. Great point.
Well, no harm, no foul. And I'm trying to keep Miss Moore out of hot water. She told us about the elephant migration in Houston, Your Honor, and was kind enough to meet us there to show it to us. So she should get bonus points for that.
Okay.
It doesn't get me out of trouble because that was a day off of work.
Right, but it was a mental health day, Your Honor, and that's good for your attorneys.
Mental health day.
Well, yeah, I need to schedule 50 of those. Okay, well, very good. Duly noted on the elephant migration.
My God.
All right. So, okay. Given what all is before the court does find that Mr. Bell's family plan of service is narrowly tailored for this case and the general concerns. And the court does hereby further make it an order of the court incorporating it therein. So, Mr. Bell, that simply ups the ante, and it's now a court order. And so if you don't perform your services and demonstrate that you've learned things, made changes if and where you've needed to, acquired or sharpened any new knowledge or skills, and if you don't do that, then down the line further in the case, the network may ask to terminate your parental rights on that ground. So let's don't have to go there. Work your services, work your services. They'll be evaluated at every subsequent hearing in this case, save and except the next hearing, unless there's an issue before the court. And recall the admonition that I have to give all of the parents, and it's this. If at the end of this case, which right now is February the 9th, 2026, although trial is presently set for December the 9th at 1:30, if at the end of this case, if you're not willing and able to provide a safe environment for your child, PB, then your parental rights may be further restricted or even terminated permanently. Now, I know you understand that, and I doubt you want that to happen. So work your services, please, sir. Don't waste any time getting started or continuing. Okay, so TMC continues, placement continues. Glad to hear the good news about the placement. And if there are no objections, I will reset mother's portion of the status hearing and any ICWA information to May the 13th, and let's say 9:30. So May the 13th, 9:30, and y'all, it is almost May.
It is May.
What? Okay. All right. Anything else? Okay. All right. Well, Ms. Bythewood, make your proclamation. We enjoyed being in your city yesterday for a couple of hours. And
I'm sorry I missed you. It was, that lazy river.
yeah. Well, what about them Rockets? We do have a team in the playoffs already, so avoided elimination. And the dogwood, the new dogwood on the courthouse lawn is growing. It is growing.
Good. Well, I remember the 90s when we were winning with the Rockets, so hopefully.
Yeah, that's right. Okay, anything else from anyone else? And if you all will let me cross-pollinate for just a moment, Ms. Moore, regarding the Monday Chambers County docket, we'll do our very best to accommodate.
Thank you. I apologize, and I really don't think it will. As long as they let us get up and prove it up quick, we'll be out and I'll be on my way.
Okay. All right. Very good. Okay. One of these days, I'm going to find a judge that I can trump and say, no, I'm not going to share it today. So anyway, thank you all very, very much for your work. Please take care. And if there's not anything else, we will stand adjourned. All right. A very good afternoon to everyone. The Second Region Child Protection Court number 1, Tyler County, is now in session. We have one matter on our virtual docket this afternoon. It's good to see everybody. Looks like we have just about everyone here. First, someone let me know that you all can hear me.
We've got you, Judge.
All right.
Where's your email at? Where's your email at?
Okay, it looks like we have everyone except Mr. Buck. Is that correct?
I don't see him here yet, Judge.
All right, I believe I remember him saying he had a couple of parole hearings. So maybe somebody can reach out to him.
I spoke with him just briefly a few moments ago, and he said he didn't have a link to it yet because it wasn't in his schedule.
Okay, well, we'll see if we can get him a link then. If
Yes,
maybe
sir.
you could forward him the link, Ms. Chandler. Thank you.
I don't have his email to be able to do that, or I would absolutely.
Okay. All right, stand by. Thank you.
Judge, I don't see him on the email list. of people that Cheryl emailed.
Okay, so if somebody can email him, Ms. Chandler, maybe you can text him the link. I'm not completely sure.
I don't have his email, otherwise I'd send it to him.
Judge Lockwood, I have emailed it to Mr. Buck.
Okay, Ms. Vargas, thank you so much.
My mom is trying to log in and it's telling her that the Zoom meeting doesn't start until 3 p.m.
Well, that's actually the end time. So keep trying. Maybe confirm the information she has.
Yes, sir.
Thank you. All right. And Ms. Walker, are you ready? Good afternoon.
Good afternoon.
Okay, let's call. We will go by the child's initials KK this afternoon, as this motion hearing pertains only to the youngest child in this case. Mr. Buck, good afternoon. Let me make sure you can hear me.
I can hear you. Thank you, Judge.
Okay, very, very good. And Ms. Kinstall, it seemed like a moment ago you could hear me. And Ms. Bythewood,
Yes,
thank you. Can you hear me over your chewing?
so sorry. They just brought me Picket House and I was trying to do it off camera real quick, but it's so good and it's fresh fried chicken.
You lose. I can never decide between the syrup and the honey there.
You don't have to. You get two biscuits.
Oh, okay, two biscuits. And cornbread if you ask. Okay, let's see. I think we're all here. Ms. Chandler's here. She's been helpful disseminating the information. I believe I see Mr. Smith. So the court will note that the parents, you all forgive them. The court will note that the parents are present. And with that, any requests for any opening statements? I don't believe I need them. Remember, we are live streaming on YouTube in order to maintain public access in open courts, as this is a virtual hearing by agreement this afternoon. So again, we'll be very careful to only use the child's initials. So unless there's a request for opening statements, Ms. Walker, unless there's an agreement, and I haven't heard of one, then you may call your first.
Thank you, Your Honor. I call Ms. Hafford.
Okay, Ms. Hafford, if you will raise your right hand, we'll get you sworn in.
Yes.
Okay. All right. Thank you. And Ms. Escobar, thank you. All right. So, Ms. Walker, you may proceed.
Thank you, Your Honor. Would you go ahead and state your name, please?
Jasmine Hafford,
And how are you related to this case?
the case manager.
Okay. And now, Ms. Hafford, we're here today asking for a change in placement for the child KK. Is that correct?
Correct.
Okay. And first of all, how's he doing?
He's doing well.
Okay. And where is he currently placed?
He is currently at Miss Linda's home as of right now, but he's placed with Miss Chandler.
Okay. And I believe he was placed with Miss Linda temporarily at the last court date.
Yes, ma'am.
Okay. And how's he been doing in our home?
And doing great.
Okay. Any concerns at all since he's been there?
No, ma'am.
All right. Prior to being at the home of Miss Smith, I believe you said he was placed with Miss Chandler.
Correct.
That's his official placement.
Yes, ma'am.
Okay. And you're asking the court today to change that placement. what concerns has the network had in regards to his placement with Miss Chandler?
Our concerns that Miss Minnie Chandler and Mr. Chandler were overwhelmed with the older children that are placed in the home. The
I would
older
object as
siblings.
to speculation, Judge.
Your Honor, that
Well,
wouldn't be necessarily
overruled.
for the, okay.
Overruled.
You can continue.
And the second, another concern was the caregivers being unwilling to protect KK from his mother.
Objection, speculation again, Judge.
Overruled as to the concerns. You may continue.
In the sense of mom's testing and the rules that were set forth and the rules not being followed out.
Okay. Well, first of all, what rules are you referring to?
Once mom tested, we asked caregivers to that all visitation be supervised with mom and that mom wear our version of PPE, which is long clothing, long sleeve shirt, long sleeve pants, wash her hands due to the testing.
Okay. And now, has mom been testing when asked?
No.
Okay. When was the last time mom submitted to drug testing?
I believe February the 17th.
Okay. And when did you request that she drug test again?
Was requested, let's say last week. Let me double check. She was asked to test on April the 24th,
Okay.
in which she
go ahead, I'm sorry.
In which she stated that she was in court that day and wouldn't be able to. And so I asked if she could test the next day, which was a Friday. And then I checked in last week on Tuesday to ask her, was she able to take the test? And she stated that she did not.
And did she tell you why she did not?
Yes, ma'am. She said that she thought that she had notified me that she couldn't, but she said that she couldn't take off of work. She said that she works Monday through Friday from 7 to 7 for home health care with a client, and that she is needing at least a 3-day notice before she's able to take off.
Okay. Now, you said prior to the April testing, it was February she tested?
Yes, ma'am.
Okay. Was she requested to test in March?
Yes, ma'am.
Okay. And when in March was she requested to submit to a drug test?
Give me just a second.
Judge, I'm going to object as to relevance. If we're moving a child, it's because there's a safety issue in the home, and I don't know that my client's compliant with services is relevant to that.
Your Honor, I believe it. I'm sorry.
Oh, no, you go ahead.
Overruled. Overruled.
She was asked to test March the 5th and March the 19th.
And on March 5th, did she tell you why she didn't test?
No, ma'am. I had no contact with her.
Did you attempt any contact with her?
Yes, ma'am.
And what did you attempt to call her by phone or email her? How did you try to make contact?
Both ways, emails, phone calls, as well as reaching out to Miss Chandler, Miss Minnie.
Okay. And what was the second date in March that you requested that she test?
19th.
Okay. So between March 5th and March 19th, did you have any contact with her?
No, ma'am.
Okay. And on March 19th, how did you relate to her that she needed to go and submit to a drug test?
Donor pass was sent via her email.
And did she respond to that email?
No, ma'am.
After the 19th, were you able to, if it was the next day or a week from that time, were you able to reach her?
Yes, ma'am. She reached out to me, I believe that Friday. I don't know the exact date.
And what did she tell you when she reached out to you?
She stated that she no longer had a cell phone anymore, and that she was not living on her parents' property. She was living with a friend, couch surfing. She also stated that she was not currently on her medication due to not being able to afford it. We also discussed the options of what to do moving forward. We discussed substance abuse classes and things of that nature.
Did she admit to you at that time that she had been using?
She admitted that she had used prior. Yes, ma'am.
Okay. When you say prior, what time frame are you speaking of?
She stated in February.
Okay. And you said you talked about a plan going forward. Um, can you elaborate on that a little bit further as to what was there anything additional besides the services that she was already supposed to be participating in?
Yes, ma'am. We talked about the previous facility that she was in, Cypress Lake. I asked would she like to go back there to start over. She stated that that was not necessary. I told her that I had put in a request for referral with ADAC to start over with ADAC, and that she needed to reach out so that she could get testing and resume her services.
Okay. So she felt like she didn't need to go back to rehab.
So,
Now, I believe you said you also asked her to test in April, and I guess the next day after an April court date. And I believe your testimony was that she did not take that test. And did you discuss with her any consequences of not taking her drug test when requested?
do not recall.
Do you recall what it was you said to her when she missed the April test?
No, ma'am. I have, other than checking in to ask her if she took the test, that was the only time I talked to her.
Okay. And when you talked to her in April and you asked her if she had taken the test, did you ask her why she had not taken it after she said that she hadn't?
Yes, ma'am. That's when she stated that she couldn't take it due to work.
Okay. Do you know how often? Well, let me back up. Do you know when it was that she actually, I believe you said she told you she moved in with a friend? Do you know actually the time that or the time frame when it was exactly that she moved?
No, ma'am.
But she didn't inform you until April?
March.
In
The end
March.
of March.
Okay. Okay. And how long prior to that time had she been staying with her mother?
I am unsure. I had no contact with Miss Sosa until the end of March.
Now, do you mean staying with her mother or staying on her mother's property?
I believe it's staying on her. I believe she was on her mother's property. So you're saying that you did not know when it was that she left her mother's property?
Correct.
Okay. Now you said you had no contact. Was it or what was the time frame that you did not have any contact with her?
Toward the end of February until the end of March, so about a month.
Okay. And what attempts did you make to contact her?
I placed phone calls, emails, and I reached out to Miss Minnie asking if she could let her know that I was looking for her and that I needed her to call me.
And did she finally call you or you had to call her?
She finally called me at the end of March.
Now, during the times that she was on her mother's property, do you know how much contact she had with the children that were there with her mother?
No, ma'am. I'm
Objection,
gonna
speculation.
I just asked how much, Your Honor.
Overruled.
Speculation.
no, ma'am.
Either
I'm
you know
unsure,
or are you
I'm
do you
unsure
know
of the
whether or not
exact
she
amount
had?
of time.
I'm sorry.
I'm unsure of the exact amount of time due to the living situation. She did see the children every day.
Okay, so she did see them every day. You just don't know about how much time she spent with the children.
Yes, ma'am.
Okay. Knowing that she was seeing the children every day, and this included Kieran, is it Kieran?
Okay.
KK?
Yes.
I'm sorry,
Yes.
Your Honor. Apologize.
Yes, ma'am.
Um, so you don't know if she was having extensive contact, if she was having physical contact with the child. In other words, holding the child or touching any of the children.
Correct.
But what you do know is during that time or during a time frame that she was there, she was not drug testing.
Yes, ma'am.
Objection asked and answered. Objection
Okay.
leading.
And I believe
One more time, Mr. Buck.
I believe that's been asked and answered, and it's leading.
Sustained.
did it concern you that you were not able to, or she would not honor your request to drug test? And
Objection
in
leading
addition,
and asked and answered.
Overruled.
was it concerning the missed drug test in addition to the admittance of her use in February? Was it concerning that she was having daily contact with the children?
Yes, ma'am.
Now, in addition to the situation with the mother and her drug testing and having contact with the children, was there also additional concerns in regards to the child KK?
Did not hear you, Ms. Walker. Can you restate the question?
I said, in addition to the mother not drug testing and having contact with the children, were there other concerns in regards to KK that the network or the department was really concerned about as far as his care?
Yes, ma'am. As I stated earlier, the older children and their demanding needs, as well as Kieran's skin. He has eczema, and his flare-ups have been really bad. I had spoken with Miss Chandler about getting him an appointment and asking for a referral for a dermatologist to get his needs met.
Okay. And were there other concerns?
There was a concern about his, like I stated before in court, his shoes. The home has, I'm going to say plywood floor. And so, of course, anything going into his foot when he's running around. And so I had talked to Miss Minnie about shoes on numerous occasions.
And what was the response when you spoke with her?
She stated that she would get his shoes put on.
Okay. And to your knowledge, did she?
I am unaware.
I'm sorry.
Not while I was in the home.
You said not while you were in the home?
Yes, ma'am.
Okay. And if you, or when you showed up at the home and he didn't have the shoes on and was running around, did you bring it to her attention?
Yes, ma'am.
All right. Now, as to the father, Mr. Smith, how has Mr. Smith how has he been doing in regards to his services?
Been doing good.
What all has he completed?
He has completed his psychological in his substance abuse assessment.
And did his psychological recommend any type of follow-up or counseling?
Yes, ma'am. We put in a referral for mental health services through Legacy.
And has he been able to initiate those services?
No, ma'am. We are still awaiting for an opening at Legacy.
Okay. And I believe you said he completed a substance abuse assessment.
Yes, ma'am. Through Counsel on Recovery.
And were there any recommendations based on that assessment?
Yes, ma'am. They recommended AA.
And has he started attending AA?
Yes, ma'am. Recently he did.
And do you know how many sessions or meetings he's been able to attend?
I'm not for sure. I know one for sure.
And now as to his housing, has he been able to locate housing?
Yes, ma'am.
And where is he staying at this time?
He is living in Highlands, not far from his mother, Linda.
And is he did he purchase a home, renting a home, or what is the, I guess, actual physical structure he's living in?
I'm not sure if he is renting or renting to own. I'm not sure.
Okay. But as far as you know, it is a house.
Yes, ma'am. He was able to show me pictures at the last court date.
Okay. Now, have you also requested the dad to drug test?
Yes, ma'am. He has taken drug and alcohol tests.
Okay. And have there been any concerns about, in regards to, first of all, his drug testing?
No, ma'am.
Have there been any concerns in regards to his alcohol testing?
At the beginning, there were concerns with him not wanting to test. However, he has been testing as of lately.
Okay. Any concerns about his results?
No, ma'am.
Now you're asking that KK be moved to Mr. Smith's mother's home. Is that correct?
Correct.
And at this time, why are you requesting her home?
I believe that Miss Linda is able to provide a safe and stable housing for him, which will allow him to be in the home with one of his older siblings. One of the older sisters is placed with Miss Linda, and it will also allow him to build a relationship with his father, Mr. Smith, who is close in the area.
Okay. And at this time, Mr. Smith is the parent that's following and participating in what's been requested of him as far as his service plan.
Correct.
And would the goal be possibly that at some point that the children, or Kieran or one or both of the children, be able to be in the home with Mr. Smith?
Is the goal for Mr. Smith. He would love that.
Okay. And do you feel that it would be in the best interest of the child KK at this time to be placed in the home of his paternal grandmother, where one of his older siblings is placed, and close to where his father at this time, who's doing well?
Yes, ma'am.
Anything else you would like for the court to be made aware of?
No, ma'am.
Do you feel it's in KK's best interest at this time to be placed in the home of Linda Smith, his paternal grandmother?
Yes, ma'am.
I'll pass the witness, Your Honor.
All right, thank you, Mr. Buck.
Hey, ma'am, is there when you're asked about safety concerns, it sounded like you said that the safety concern for the child was that he was running around barefooted in the area. Is that right?
Yes, sir. That is one of the concerns. Yes.
And this is a family lives out in the country. Is that fair to say?
Correct.
And you made the request to the grandmother to put shoes on him, and she said she would do it. Is that correct?
Correct.
Do you have any evidence that she did not do it?
No, sir.
There were quite a few questions about mother's compliance with service plan. Is it generally the concern, the safety concern, is that my client, the mother's having unsupervised access with the children?
Can you repeat that for me, Mr. Book?
Is the network's concern that the mother is having unsupervised access with the children?
Yes.
Do you have any evidence of that?
No, sir.
Do you know where the mother's living now?
Do not have her physical address.
Okay. How often did you go out and visit the kids at grandmother's house, the maternal grandmother's house?
See them once a month.
So how many months have you gone out there?
I believe since August or September.
So it's 8 months or so, fair to say.
Yes, sir.
Okay, other than the shoe issue, were any of the kids, unclothed when you went out there, inappropriately clothed when you went out there?
Not that I can remember.
Did any of them appear to be malnourished or underfed when you were out there?
No, sir.
Did any of them have any unexplained injuries when you went out there?
There was an intake for Kirian. I don't know I can't recall the exact month, about a injury to his cheek. I believe
Okay,
it was his cheek.
let's make sure we're using the child's initials, please.
Sorry, KK.
And was that just a slight bruise or a bruise?
Yes, it was a bruise that grandmother stated that he fell on the concrete.
I'm sorry, could you repeat that?
His grandmother stated that he had fell on the concrete.
When you've gone out there, are these kids allowed to run around and play outside in the country? And would this type of injury be reasonably explained by her explanation and kids being kids?
Yes.
Does the department have any evidence that the maternal grandmother has missed taking any of these kids to a doctor's appointment and not made it up?
When you say doctor, you mean just doctor, no other types of?
I'm just asking about medical now. I'll ask you about the others.
Okay. Not that I'm aware of.
Do any of these children see any types of specialists or need to see any specialists regularly?
No one currently sees a specialist. The oldest daughter is in need of a specialist for her dental work, and KK is in need of a specialist for his eczema.
Any concern that the grandmother won't be able to schedule and make an appointment for the dental work needed for the oldest child, for the daughter?
I am unaware if she has done so yet. We have discussed the option that is for her to use. I don't know if she's used it as of yet.
And the eczema, that's a new specialist that's been identified. Is that correct?
Correct.
So when was it determined that this child needed to go see a dermatologist?
Do not remember the exact month.
Any evidence at all that the grandmother is not appropriately addressing these two issues for these kids?
No, sir.
Fair to say that since we're leaving some of the children in this grandmother's care, that we don't have a safety concern for her ability to care for these children.
There is no safety concern for the older children. There is a safety concern for KK.
What safety concern is there that applies to one child and not the others?
As I stated earlier, being overwhelmed with the needs of the older children and not being able to protect Kieran from his mother.
KK, Ms. Hubbard.
KK.
By protect, you mean possible unsupervised access?
That's part of it, yes, sir. And then the not having on the proper clothing during her visits.
Okay. Have you observed her visits with the children at the grandmother's place?
No, sir.
Okay. So do you have any evidence that she hasn't been properly clothed when touching or having physical contact with these kids?
I have spoken with my coworkers from kinship who has observed her not being properly clothed.
Is that person present to testify today?
I believe so.
Okay.
Yes, she is. She is present.
Are we sure this isn't a situation where we're punishing a parent for not working services and rewarding another one?
No, sir.
We're not sure, or we're not, that's not it?
That's not it. We're not punishing anyone.
And I apologize if I asked, do you know where the mother lives now?
I do not have her physical address.
But is it fair to say that it's not on the grandmother's property?
Is what she has stated to me.
Okay.
That it is not on the property.
It would be fair to say that the kids, this little child's barefooted shoe is a small thing, and the real concerns is the possible unsupervised access and possible inappropriate clothing when in contact with the kids. Those are the primary things.
Correct.
Okay. And this kiddo's been there 8 months or so?
No, sir. He was placed there in, I believe, December.
Okay. So it's 6 months or so.
I believe so.
Okay. If the concern was about how the visitation or contact with the mother and this child or the children is going, wouldn't making the visitation supervised by the department at the department's offices resolve these safety concerns?
I am unsure if it would resolve them.
But that's not what you want to happen, fair to say.
Can you repeat what it is?
You don't want visitation to stay. You don't want placement to stay the same.
No, I would not like placement to stay the same.
And were you present in the courtroom last week?
Yes, sir.
Did you observe anyone tell my client that if she fought this too much, the other children might be at risk of being moved?
No, sir.
Your Honor, I would object to that. That's a mischaracterization of something I believe I said.
Judge, I had conversations with my clients, and I felt it was necessary to ask that question.
Overruled. Overruled.
I passed the witness, Judge.
All right. Thank you, Ms. Kinstall.
Thank you, Judge. All right. Ms. Hufford, what's mom's drug of choice, if you know?
Methamphetamines and amphetamines.
Okay, and is that the reason the network has asked for her to wear long sleeve clothing?
Yes, ma'am, due to testing positive.
Okay, because it's transdermal?
Yes, ma'am.
Have you been able to confirm that mom is no longer residing at maternal grandmother's property?
No, ma'am.
And I think you stated earlier you haven't been able to confirm that mom is living elsewhere either. Is that correct?
Correct.
So basically, you're just having to take the word of mom and her mom, right?
Correct.
Okay. Has maternal grandmother ever given you a reason to not trust her or to doubt what she's telling you?
Objection calls for a narrative answer, Judge.
It's a yes or no.
Overruled. You may answer.
Yes.
Can you give an example?
For example, on my visit for the month of April, I went out, I had pre-asked for Miss Minnie, to have her daughter present, or asked her daughter to be present during the visit. However, when myself and Casa got there, she was not. During our visit there, I asked grandmother to call and see if she could come over for the visit. She stated that mom did not have a phone at the time, so she had to call her the patient that she sees phone, and she said that she didn't get an answer. However, when I talked to the children, we talked to the children alone. One of the children stated that mom had her own phone, that they talked to her own. And so that showed that grandmother was not being honest with me.
Okay, so maternal grandma says mom doesn't have a phone, and kids say yes, she does.
So no.
And when you say you talk to the kids, are you talking about the teenagers or the little kids?
Children.
All of them?
I talked to all the older children, yes, ma'am.
Okay. Okay. Have you received any pay stubs from mom for this caregiver job she says she has?
No, ma'am.
Have you received a copy of the work schedule for mom's job that she says she has?
Ma'am.
Have you received any other verification that mom is employed as she claims to be?
Ma'am.
Is that part of her service plan that she's supposed to be working?
Yes, ma'am.
And that she's supposed to provide proof of employment and income to you as the case manager?
Yes, ma'am.
I want to ask you some questions about the kids that are currently placed with maternal grandmother without using their names, right? We have KK, who is 2, right?
Correct.
And then there are 3 teenagers, correct?
Yes, ma'am.
Okay. And the youngest teenager is what, 15?
14.
14? Okay. Is it fair to say that the level of supervision that a teenager requires is going to be different than a 2-year-old would require?
Yes, ma'am.
Well, and I guess there's an argument to be made that for these 3 teenagers, they need a heightened level of supervision too, though, right?
Yes, ma'am.
Okay. The oldest boy in maternal grandmother's house, he refuses to go to school, right?
Correct.
Okay. And the oldest girl in maternal grandmother's house had truancy court recently, correct?
Ma'am. That was the
second oldest
girl.
Okay, I'm confusing my kids because they all have the same initials. Okay, what about the oldest girl? Is there a concern that she is also having frequent absences at school? Is that a yes? I'm sorry.
Yes, ma'am.
Okay. Are you, and by you, I mean the network, is the network asking to further restrict mom's visits based on everything that you testified to on direct in response to Ms. Walker's questions?
Judge, I would object as to relevance. That a change in visitation schedule hasn't been requested in any review.
Well, overruled. I want to make sure, however, that Ms. Hafford heard and understood the question.
Let me try to ask it
Hear it.
in a not overly lengthy way. Is the network asking for mom's visits to be further restricted?
Are we talking about for all the children, or are we
Well,
just
okay, let me confirm something first with you. Are mom's visits with the children that are currently residing with the maternal grandmother, the 3 teenagers and KK, are those visits supervised by maternal grandmother? Okay. Is the network asking for some other sort of arrangement to supervise mom's visits with those 4 children that live with maternal grandma?
not for all 4, just for change? We would like the placement for KK.
Okay, so if KK is moved, if his placement is changed, then what will the visitation arrangements be between mom and KK?
They will be supervised.
Okay, well, but by whom?
By either the network or by the caregiver, Miss Linda.
Okay, so not by maternal grandma anymore.
No, ma'am.
Okay. Do you agree it's probably more important for KK to have adequate supervision because of his age with
Correct.
mom?
Correct.
And because 2-year-olds put everything in their mouth, right?
Correct.
Their hands.
Yes, ma'am.
So if he touches mom and she's been using meth, then he could potentially ingest that, right?
Correct.
I want to ask you about, I know Mr. Buck said that, or you said in response to Mr. Buck that you visit the house monthly, maternal grandma's home, right?
Yes, ma'am.
Okay, let's talk about your attempt to visit maternal grandma's home in April. Did you attempt to visit maternal grandma's home last month, April 2025?
Yes, ma'am.
How many times did you attempt to visit?
I believe 3 times.
And were you successful any of those 3 times?
Was successful on the last attempt.
Okay. Were they all pop-up visits?
The first one was unannounced.
Okay. And what happened that you were unable to visit that time?
Miss Minnie stated that none of the children were home at the time.
Okay. And did you subsequently find out that that was true or not true?
I pulled into the yard to turn around and I observed her outside playing with some younger age children, but I could not verify who the children were.
Okay. And that was immediately after she told you that they weren't home?
That the children were not home. Yes, ma'am.
Okay. What about the second attempt to visit the maternal grandma's home last month? Was that an announced visit?
Yes, ma'am. The day before when the unannounced was supposed to, tried to take place, she stated that we could do it the next day. So it was a planned visit.
And were you able to visit that following day?
No, ma'am.
Why not?
She stated that I believe the oldest child would not be home. She was still somewhere else. And she stated that one of her other grandchildren were sick and was going to be having to go to the hospital.
Okay. And were you able to confirm whether or not all of that was true?
No, ma'am.
Okay. And then the third visit attempt, is that the one that was successful, or was there another unsuccessful visit attempt?
I believe that one was successful.
Okay. And were you able to see all 4 children placed in maternal grandmother's home on that visit?
Yes, ma'am.
Okay. Did you have any concerns about the cleanliness of the 2-year-old during your April visit?
Cannot recall.
Okay. So is it fair to say that your interactions with maternal grandmother in connection with your attempts to visit in April, would that be another reason she gave you not to trust her?
Yes, ma'am.
Dad, Mr. Smith, he's in compliance with this service plan. Is that correct?
Yes, ma'am.
And Dad's never tested positive on an ETG drug test for alcohol, right?
Correct.
He has a breathalyzer in his car too, in fact.
That is what he has stated. I have never seen the breathalyzer.
But didn't he send you pictures of it?
I do not recall.
Okay. What about his last hair test? When was that?
I do not recall.
Have you visited Dad's new home yet?
No, ma'am.
But I think you said earlier you've seen pictures of the house.
Yes, ma'am.
And that is close to paternal grandma, right?
Correct.
And right now, KK is on a visit to paternal grandma's, right?
Yes, ma'am.
And then paternal grandma's got is she 9?
9 or 10.
Okay. So a child that's closer to KK's age than the 3 teenagers at the other grandma's house, right?
Correct.
Does Dad have any children living with him right now?
Yes, ma'am.
Okay. And is that Grayson?
Yes, ma'am.
Okay. And he's not part of this suit, right?
No, ma'am.
He's 7? 7 years old?
I am unsure of his age.
Okay. And how did he come to live with Dad, if you know?
Dad stated that CPS reached out to him to pick up his son.
What happened to Mom, if you know?
He stated that Mom was incarcerated.
Okay. So why not ask the court to place KK with his dad instead of Dad's mom?
Mr. Smith has not said that he wanted the child placed with him. We discussed the child last week, and he was in agreement with the child being placed with his mother.
Well, when did you talk to him?
On the 30th when we had court.
Okay. Well, if I was to tell you that he would like placement of KK, do you have any reason to disbelieve what I'm representing to the court?
No, ma'am.
Okay, so other than you think that Dad doesn't want KK, are there any other reasons why the network is not trying to return that child to a parent at this time?
I would have to refer that to my supervisor.
Okay. All right, I'll pass the witness. Thank you.
You're welcome.
All right. Thank you, Mr. Keating.
Thank you, Your Honor. Ms. Hafford, this is not about the parents being good or bad or trying to punish one over the other, is it?
No, sir, it's not.
In fact, when you first brought this to my attention, it was more concerns on KK's appearance and care. Is that correct?
Correct.
Now, Miss Chandler, and it's also not that she's a bad person, is it?
Correct.
Are you concerned that KK is being overlooked because of the problems with the older children at the maternal grandmother's house?
Yes, sir.
And it's a small home, isn't it?
Yes, sir.
And the network is happy that Ms. Chandler has stepped up and was taking care of KK and the other 3 children that are there, correct?
Correct.
But as you responded to Ms. Counsel, you've had some issues getting in touch with Ms. Chandler, haven't you?
Yes, sir.
Quite a few, as a matter of fact. Is that correct?
Yes, sir.
And are you aware that CASA has also had troubles?
Yes, sir.
Your Honor, I think we need to clarify which Miss Chandler.
Oh, I'm sorry. Let's make it Minnie Chandler. Thank you, Ms. Bythewood.
Sure.
If we could use since I'm new to the case,
I'll
Judge,
use
if we could use
grandmother.
grandmother and mother, I would appreciate that. Thank you.
You bet. I can do that, Mr. Buck. Not a problem. There's a lot of people in here.
Well, we actually need to do maternal grandmother, paternal grandmother.
I was going to try to do that, Judge. Now I forgot where I was. No, you have actually had quite a bit of trouble getting in touch with maternal grandmother, right?
Correct.
And I think I asked you that CASA has also expressed difficulties too.
Correct.
Are you aware that CASA actually sent out an email asking us, attorneys ad litem and attorneys, to try to assist her in that?
Yes, sir. She talked to me about it.
Okay. That's a concern too, because you do need to talk to the maternal grandmother whenever you try to get in touch with her to find out how the children are doing, don't you?
Correct.
And let's go back to the issues about the dermatology referral for KK. That didn't happen in the last 30 or 20 days. It's been going on for a couple of months now, hasn't it?
Correct.
And unfortunately, maternal grandmother just hasn't followed up with getting that done, has she?
No, sir.
How long have you been trying to get, and I don't know which girl it is, the dental appointment?
The oldest girl, I am unsure.
Over a month?
I want to say yes. It was our last court hearing, and I believe that was at the end of March.
Okay, not the one we had last week, but the one that was the end of March.
Sir.
Okay. Have you had a chance to visit KK at the paternal grandmother's house?
No, sir.
Have you talked to the paternal grandmother about how he's doing?
Yes, sir.
Okay, and she's here too, so she can testify as to how he's doing. But do you have any concerns with KK being placed there?
No, sir.
Otherwise, you wouldn't ask that happened, would you?
Correct.
Okay. Sorry. Robotic vacuums are great, except when they come on in the middle of Zoom. Now, KK has been placed with Miss Smith, paternal grandmother, before, has she not? Has he not?
Yes, sir.
And the reason for that removal, or the main reason for it, was that the father was still living with paternal grandmother, right?
He was.
And at the beginning of the case, he wasn't real cooperative, and I'm trying to say that nicely. Is that correct?
Correct.
But he has become much more cooperative and has done just about everything the network has asked, right?
Correct.
So it's not just a reward to him, it's kind of a reward to KK to get to know his dad a little bit better, isn't it?
Correct.
And after all, the children right now are kind of who we're interested in, isn't it?
Correct.
I in no way, shape, or form want to malign the maternal grandmother. She has stepped up and taken on a big role, hasn't she?
Correct.
That being said, as Ms. Counsel asked and stated, and you responded to, we have the oldest child, oldest boy, who just flat refuses to go to school, doesn't he?
Correct.
Now, in maternal grandmother's defense, she did find a place in Lufkin for him to go to. Is that correct? Or are you aware of that?
When you say a place, what do you mean?
A school in Lufkin.
She stated that she had found a school.
Did she give you any information about that?
No, sir.
Okay. And then we have the youngest girl, is it correct, that just went to truancy court, correct?
Youngest girl at the maternal grandmother's house, yes.
Yeah, I'm sorry, the youngest girl, the youngest of the girls is at the maternal grandmother's house, right?
At the paternal, yes.
And do you know how she gets along with KK?
She gets along good.
She kind of mother him a little bit?
Yes, sir.
Do you believe it would be good for her also if KK were there?
Yes, sir.
Do you believe it would be good, beneficial, and a situation that it would allow KK to grow if he were placed with paternal grandmother?
Yes, sir.
I would object as a speculation, Judge.
Overruled.
Now, we have to look at what the parents are doing in this case to some extent about, because the kids are dependent upon what they do as to where they're going to end up long run, aren't we?
Correct.
So basically, mother is not doing anything the department has asked her to do. The network, I'm sorry, I'm old school. I'll never get out of that. The network has asked her to do. Is that correct?
Correct.
In fact, you can't even hardly stay in touch with her on a regular basis. Is that correct?
Correct.
On the other hand, the father is doing everything you've asked him to do, right?
Correct.
And at this point, I believe Ms. Counsel also asked you that you're considering, if he continues, possible placement with him. Is that correct?
I referred this question to my supervisor.
Okay, well, I understand right now, right?
You broke up on me, Mr. Keating, so I didn't get to hear you.
Goals haven't changed, have they?
No, sir.
No further questions of this witness, Your Honor.
All right, thank you, Ms. Bythewood.
Just briefly, Ms. Hafford, this is a non-emergency request for moving a child. Is that correct?
Correct.
And in looking at policy, pretty much both houses are equal. You both have relatives who have close relationships with the child. Is that correct?
Correct.
The child is bonded to both grandparents. Is that correct?
Correct.
There are siblings in both houses. I mean, full-blooded siblings in both houses. Is that correct?
Correct.
There are a few differences in the behaviors of some of the siblings in one house versus another. Is that correct?
Correct.
Are there any behavioral concerns in the paternal grandmother's home at this time?
No, ma'am.
Okay. And at this time, do you have one parent who is more trustworthy with visitation than another?
Yes, ma'am.
Which parent would that be?
Mr. Smith.
And which child in this case is most vulnerable?
Okay.
And in looking at the totality of the circumstances, it is in the best interest of that child to be moved from the maternal grandmother to the paternal grandmother's home?
Yes, ma'am.
Okay. Are you aware that the youngest daughter, we have I represent two ASs. I represent the oldest AS and the youngest AS. The youngest AS, she wants to live with her grandma and she wants her grandma to have custody, paternal grandmother. Is that correct?
Correct.
And the oldest AS, she's 17 and she's been more of an adult than anybody. Is that correct?
Correct.
And so realistically, are those children's desires going to have a very heavy weight at the end of this case?
I believe so.
All right. And if there's anybody talking to these children and weaponizing this situation regarding so-and-so getting custody over so-and-so, would you ask that none of this is discussed with the children?
Yes, ma'am.
I mean, they have enough stress on them that they should not have on them. And they should never have a parent, a grandparent, anybody telling them that they're going to end up someplace where they feel unsafe or uncomfortable. Is that correct?
Correct.
Okay. And again, if that's a parent, if that's a grandparent, if that's the network, if that's an attorney, nobody needs to be talking to these kids like that, correct?
Correct.
Okay. I think that's all I got. I just went through policy. Pass a witness.
All right, thank you. Back to you, Ms. Walker.
I have no further questions, Your Honor.
All right. Any other questions of Ms. Hafford, Mr. Buck, or Ms. Kenstel?
Judge, I have a couple of follow-ups.
All right. You may.
Ma'am, since you've been on this case, has the mother had the same phone number the whole time?
As far as I'm aware, yeah.
Okay. Have you ever had times when it just went straight to voicemail and you couldn't get it to even ring on you?
I am unaware, unsure.
Now, does the maternal grandmother have other grandchildren, nieces and nephews that live in the area?
I am unsure.
Okay. I've asked the witness, Judge.
All right, thank you. Ms. Walker, you may call your next.
Thank you, Your Honor. I call Ms. Young.
All right, and Ms. Young was sworn in. We'll get her unmuted and you may proceed.
Would you go ahead and state your name, please?
Ashley Young.
And how, excuse me, how are you related to this case?
I'm the case manager supervisor.
And now you've heard the testimony of Ms. Hafford. Is that correct?
Yes.
Do you have any additional concerns or anything else that you feel like the court needs to be made aware of?
Objection. Calls for a narrative.
Overruled. You may answer.
Nothing additional. Nothing additional than what Ms. Hafford spoke about.
Okay. And do you feel it's in the best interest of the child, KK, at this time to be placed with his paternal grandmother?
Yes.
Objection, relevance, Judge. There's no evidence that she's ever been to this home or visited with any of these children at all.
Overruled. Actually, Ms. Walker, let me hear the question again, please.
Did she feel it was in the best interest of the child, KK, at this time to be placed in the home of his paternal grandmother?
Okay. All right. She overruled. She may answer that.
Yes, I do.
I'll pass the witness, Your Honor.
All right. Thank you, Mr. Buck.
Ma'am, do you and your, so you're the case manager supervisor, is that correct?
I am.
And I apologize, I do a couple different counties, and some of them have traditional caseworkers who work directly for CPS, and some of them are in the network. So it's effectively you're the supervisor for the caseworker. Would that be fair to say?
Correct.
Okay. Do you and your caseworker have network issued cell phones?
We do, yes.
Do they have cameras?
Yes.
Okay. Have you personally ever gone out and visited at the maternal grandmother's home?
No, sir.
Absolutely, Ms. Judge.
All right, thank you, Ms. Kinsel. Any questions of Ms. Young?
Yes, Judge. Ms. Young, have you and your case manager staffed a return home to dad for KK?
No, ma'am. No, ma'am.
Why not?
When the concerns arose about KK, the initial plan was for him to move with back to his paternal grandmother, who lives close to the father. And at that time, the father was in agreement and did not have any objections to that. So it was not discussed.
Okay. So dad moved into a home last week, right?
From what I understand, yes.
And it was the week before that the network asked for a placement hearing, right?
I believe so, yes.
And then I guess just as a formality, there was a motion filed the day before court last week.
Yes, ma'am.
Okay. Reunification with a parent is a goal in this case, right?
Yes.
It's the primary goal? And I'm talking about just KK at this time.
Right. I can't recall off the top of my head. I would have to look at the plan.
Okay. That's all right. You probably didn't think you'd get testifying. Why is it not in KK's best interest? Well, you said it's in KK's best interest to be placed with paternal grandmother, right?
Correct.
Okay, so why is it not in KK's best interest to be placed with his father instead of a non-parent?
This time we don't know that it's in his best interest or not. We have not been able to evaluate the home. If he has a safe place for KK to sleep, anything like that. That's a new situation that we could staff about, that Jasmine and I could staff about. But at this time, we don't know. We don't have much information on it.
But it sounds like CPS in another county was okay with a 5-year-old living with him, right? With dad?
He placed the child with him. I'm not sure of that case.
Okay. Well, wasn't at least at one time there a restriction or a requirement that dad not have any, I guess, supervisory responsibilities for a child under the age of 18? Isn't that part of the service plan? Not allowed to have care. You're not supposed to be caring for a child under the age of 18.
It's not specifically in our service plans, but it is part of the general rules and guidelines.
Okay. But that was lifted, so to speak, when Grayson was placed with Mr. Smith. Is that right?
From the other county, not from our county, yes.
But TFC in Tyler County was aware that there was a 5-year-old living with dad, right?
Believe they sent Jasmine a text message during the weekend, and I don't encourage my case managers to work on the weekend, so she did not see it until Monday. So it was a few days before she knew.
Okay, but we're not talking about this Monday, right? This is a couple weeks ago.
Correct, yes.
Okay. Okay, I'll pass the witness. Thank you, Ms. Young.
Yes, ma'am.
All right, thank you, Mr. Keating.
I don't have any questions of this witness,
Okay,
Judge.
thank you, Ms. Bythewood.
I have no questions.
Okay, thank you. Back to you, Ms. Walker. Any other questions or witnesses?
No further questions, no other witnesses, Your Honor.
Okay, thank you. All right, Mr. Buck, you may call your first, if any.
I called the mother briefly, Judge.
Okay, all right. Ms. Chandler, if you will unmute, turn on your video, please. And I may need to say at this point that I expect to need to take about a 10-minute break fairly soon. So you all just bear with me on that. I'll let you know when that happens. So, but Mr. Buck, you may proceed.
Ma'am, did you hear the concerns of the, I'm going to say caseworker?
Yes, sir.
Okay. Have you ever, actually first, where are you currently living?
I actually just moved an RV today. I've been working on it at Triple Creek 47.
Okay.
Sir?
When was the last time you resided at your mother's property?
I want to say late January or maybe mid-February. I'm not
Did you ever
sure of
have
the exact date.
did you ever have unsupervised visitation with your children while they were placed with your mother?
Yes, when it was allowed, before the restrictions were placed.
When were those restrictions put in place, if you recall?
I believe the day that my mom and dad found out about the failed drug test from Miss Hafford, and I was told I had to leave the property by my parents. I had 24 hours to leave the premises.
Since that time, have you had any unsupervised visits with the kids?
No, I'm not even allowed on the property unless both of my parents' vehicles are there and both my parents are present.
Now, you're opposed to moving this child, correct?
Yes, sir.
Okay. And do you have concerns about the paternal grandmother?
Yes.
Okay. Now, has she had any children in her home that were removed and had to be moved?
Yes, my children, my older children.
Which children were previously in our home and had to be moved?
Ayla, Aiden, Aubrey, and Ariel were all removed in 2020.
Judge, I would object as to non-responsive and ask that be stricken so I can re-ask it and get initials for children since we're on YouTube.
I apologize.
It's okay. If you can answer this by saying oldest daughter, middle son, something along those lines, rather than the names of the children, I'll re-ask the question. Okay?
4.
Let me re-ask the question. Have you ever have any of your children been removed from the paternal grandmother?
Yes. A1 through 4. A1, A2, A3, and A4 have all been removed.
And what are their ages?
17, 16, 14, and 9.
And what is your understanding as the reason that those children had to be removed?
Well, the 14-year-old who at the time, I believe,
Your
was...
Honor, I would ask that in lieu of the mother's testimony, the court could refer to the girls in chambers conversation. I'm concerned about the sensitivity of this for the girls.
Okay, the court does recall and hereby takes traditional notice of that, so we can move on.
And ma'am, then with that in mind, ma'am, what are your concerns about any child being placed with the maternal grandmother?
Well, it would be referred to the things that my children have told me have happened to them, and the things that they have told the judge. I'm not sure what they told the judge. I just know what they told me, but I'm sure the judge can relate.
Judge, I'm having a challenge with that just because I am completely unaware of what might have been said. So it's difficult to represent my client on this motion without her being at least give a baseline about what her concerns would be.
In your honor, I believe that the mother and the children's story are 100% aligned based on what the mother has said in the past with her other attorney.
I apologize, but I don't have any kind of record or transcript, so I don't know what was said.
No, I understand. I was just trying to let you know that. But I mean, if y'all want to go off YouTube, however, I just wanted to make sure that I know I don't represent the other AS, but the oldest AS I still do, and her privacy, right to privacy supersedes any right for this to be a public hearing if we're going to get into that.
I agree, Your Honor.
All right, what I'm going to do, so were those having conferred with the children risen to such a level, I would not even countenance this hearing, right?
Right.
So what I'm going to do is place Ms. Chandler and Mr. Buck in a breakout room so that they might speak privately and confidentially, albeit virtually. And then I'll let me give you all about 5 minutes. We'll come back and see what, if anything, more you need to go forward, Mr. Buck. All right.
Thank you, Judge.
Okay, thank you. All right, so stand by. And so Ms. Chandler, Tulsa Chandler, you may need to watch your screen and accept an invitation into a breakout room.
Yes, sir.
Bear with me.
Your Honor, while they're in a breakout room, off docket issue, may I update the court about something?
Yes, just a moment. Yes, ma'am. Mm-hmm. Okay, so whoops, okay. All right. Do you see the invitation, Ms. Chandler? You can just accept it.
Yes, sir.
Okay. Okay, and Mr. Buck, same. Okay. Okay, do we need to go into virtual chambers, Ms. Bythewood, get off of YouTube?
If we could just briefly go off YouTube.
All right. And this would be due to the right to privacy superseding any the public might have?
Yes, sir.
All right, so we'll be closing the courtroom, as well as pausing. I didn't, but I'm about to. So with that, you may proceed. Thank you.
Ma'am.
Yes, sir.
Right. Would your concern be for this child being placed with a maternal grandmother that there's the potential for them to be exposed to physical or emotional abuse?
Objection leading.
Judge, that's my one question, to do it in a way that we can expedite this.
So I'm gonna overrule the objection. You may answer that.
Yes.
Okay. Ma'am, there's been a lot of questions about your drug testing.
Yes, sir.
If the court were to order you to drug test today, would it be positive for anything?
No, sir. A hair would show methamphetamines and marijuana. A UA would show nothing.
Okay. And when was the last time you used?
mid-February.
Okay. Have you been working any sort of program or just abstaining from drugs?
Abstaining currently because I work 7 days a week.
Okay. Does your work randomly drug test by chance?
Yes.
Okay. Judge, I pass the witness to this time.
All right, thank you, Ms. Kinstall.
Thank you, Judge. All right. Ms. Tulsa, you're at your mother's house right now, right?
Yes, ma'am.
And your mother's present with you?
Yes, ma'am. Yes, ma'am.
Okay. Is your dad home?
Yes, ma'am.
Okay. Those are all the questions I have. I pass the witness.
Okay, all right. Thank you. Did the panning show your father?
Yes, sir.
Was that
He was in the garage, Judge.
okay? All right. All right. Thank you, Mr. Keating.
I don't have any questions, Judge.
Okay, thank you, Ms. Bythewood.
Yes, ma'am. Ms. Tulsa, your mother's property, it's a large piece of property, is that correct?
It's just under 1 acre.
Okay. And if you're living in town, that can be large, but it's completely fenced, is that correct?
Yes, ma'am.
In the front part of it, is there a play area for children that's well maintained?
Yes.
And even in the back part of it, your father does construction, so there are bits and pieces of stuff back there. Is that correct?
No.
Okay. Okay.
Mr. Keating said that he was there, so.
Well,
sorry, could you ask the question again?
okay, your dad does construction remodel, so there's construction equipment there, and I don't mean equipment like a dozer or anything, boards, trailers,
Yes,
that
ma'am.
kind of thing. But even with that there, it's also well maintained. Is that
Yes.
correct? Okay. And even though your mother's trailer has boards pretty much for the floor, they're clean, aren't they?
Yes.
She maintains a clean home, doesn't she?
Yes, ma'am.
So, I mean, there's pluses and minuses because you've been in Miss Linda's home, is that correct?
Yes.
So there's pluses and minuses to both homes, but at your mother's home, there's a place for this child to pretty much run around and get some of that energy out. Is that correct?
Yes, ma'am.
And that doesn't necessarily exist at Miss Linda's home, does it?
No, ma'am.
Okay. You understand what the concerns from the network are, don't you?
Yes, ma'am.
Okay. And that's primarily why they're asking for this. You understand that, not to punish you, just to protect your child during this time.
Yes, ma'am. But my mother and my father have removed me from the property and taken all necessary precautions. My mom has a set of clothes that I'm required to wear every time I step on the property. As soon as I step on the property, I'm expected to go straight to the bathroom and change.
Right. And there's not been any testimony about your mom's property. And that's why I wanted you to tell the judge about where she's living. And it's right there on the highway, but not in a dangerous location, correct?
Correct.
So it's country, it's near the river. There's going to be bugs, aren't there?
Yes, ma'am.
Okay. But other than that, there's room for the child to move, correct?
Yes.
I'll pass you as a witness.
All right, thank you, Ms. Walker.
No questions, Your Honor.
All right, thank you. Back to you, Mr. Buck.
No additional questions, Judge.
Okay, thank you. Then you may call your next, if any.
I have no further witness.
All right, thank you. Ms. Kinstall, you may call your first.
No witnesses.
All right, thank you, Mr. Keating.
Your Honor, I'm going to call Miss Escobar.
All right, Ms. Escobar, if you can unmute and resume your video and let me make sure that you were sworn in earlier. I believe you were.
Yes, sir.
Okay. All right, so just let us know when you're ready
I'm ready.
and
I just had to
stationary.
close
All
the
right.
door.
Okay, very good. Thank you. And Mr. Keating, you may proceed.
Thank you. Be short, Ms. Escobar. Would you state your name and how you're related to this case, please?
My name is Gardenia Escobar, and I'm the kinship case manager.
And quickly, have you visited or been at Miss Chandler, the maternal grandmother's home, when Tulsa Chandler has been there with the children?
Yes.
And did you see Miss Chandler visit with KK without appropriate restrictive?
Ms. Hope, you're still here, aren't you?
I'm here, Judge, finally.
Okay, so let's redo all of that because everybody except Ms. Hoke and I froze.
Ms. Escobar, did you hear my question?
No, can you repeat it, please?
I'll be happy to. I was afraid everybody froze, to me too. Have you been at the maternal grandmother's home when Miss Tulsa Chandler, the mother, has been there visiting with KK?
The time that I saw it was the oldest teenage boy.
That's who you were seeing?
Yes, she was there with him, and he was inside taking a nap.
Okay. Have you seen her with KK at all?
No.
Okay. I don't have any further questions then, Judge. I was under a misunderstanding. Thank you.
All right. Thank you, Ms. Bythewood.
Have you seen the mother visit with KK without the necessary PPA or PPC or whatever that stuff is?
No, ma'am. Not with KK.
Okay. Nothing further.
Okay, thank you. Ms. Walker.
No questions, Your Honor.
All right, thank you, Mr. Buck.
No questions.
Okay, thank you. And Ms. Kinstel.
No, sir.
Okay, all right, thank you. Okay, thank you, Ms. Escobar.
Yes,
and,
sir.
You can be excused if you need to, but then again, you may also stick around. So with that, Mr. Keating, you may call your next.
I have no further witnesses, Judge. Thank you.
All right, thank you. And Ms. Bythewood, you may call your first.
I have no witnesses.
All right, the court will receive brief closing arguments, beginning with Ms. Walker.
Thank you, Your Honor. As been stated and through the testimony of the network feels it's in the best interest of the child, KK, that he be placed with the paternal grandmother. There's concerns in regards to the current placement with still with the mother having contact. I believe she testified that she may change clothes or she does take some type of precaution, but we still don't know if that's every time and really how much access that she has to the child. There's been some concerns that the network has expressed to the grandmother, Miss Chandler, in regards to especially with the situation with the floor and the child's protecting the child's feet. I don't believe that there's been testimony that that issue was resolved, and I don't believe it was just a matter of the child being exposed to a bare floor or a bare wooden floor, but that there were hazards with the floor, and that's why the network was asking that precautions be taken. In addition, we have the mother who's, I would say, avoiding drug testing for the past couple of months. She did admit to use and a relapse back in February, but then the next 2 months she still refuses to test, and when she's asked to test by the network. So there's some concerns. There's also the concerns with the other children that are in Miss Chandler's home, and the situation that that's putting her in. Her hands are full with those children, but then also she has a small child that she's trying to care for as well. And in addition, Your Honor, we have a father. I don't think anybody would disagree. They got off to a very slow start, and I'd say slow and rocky start. But he's picked it up. He's was living in a shelter. He's been able to secure housing. So he has employment. So he's been doing the things that he needs to do, and that the network is asking him to do, which has not always been his attitude in this case. His mother, he has a child placed with him. His mother, I believe, also has one of his older children there in the home. And I believe through testimony, Your Honor, it can be determined that that home is less chaotic than the home of Miss Chandler, and that there would be extra time and attention that could be given to KK, and that he would need due to his age. I believe that and the evidence has shown that it's in the best interest that the child be moved to Miss Smith's home. I believe that the evidence shows that the situation that the father is in, that he would be a positive help to his mother if the child was placed in the home, and it would be in the child's best interest, Your Honor. Thank you.
All right. Thank you, Mr. Buck.
Judge, I think from my view, this is one of a classic CPS motion setting to change placement, where we have a lot of feelings and not a whole lot of evidence. Well, I know the concerns are there, but there's no firsthand witness or photos or anyone that testified that they saw the mother with the children unsupervised. There's same thing for inappropriate clothing, or that she was having physical contact without proper PPE on. The concern about the child running around barefoot, I'm sorry, I just don't see that as a risk to begin with. But even if it were, the caseworker testified that she mentioned it to the caregiver, and the caregiver responded that she would take care of it. And there's no evidence that she did not do that. The testimony that's before the court was that the children, every time the caseworker went out there and visited, were appropriately clothed and fed and hadn't missed any doctor's appointments. There apparently has been some delay about some recent specialists. Forgive me, but I'm not familiar with the area. Specialists for a teenager's dental issue and a child's eczema, that very well could be just a challenge finding a specialist in a rural area. I understand that they have concerns, and I don't know that I've been a part of a placement motion hearing where moving from one relative to another, where the parent service plans were talked about so much, which very much gives me the concern that, this isn't just about best interest of the kid. There's something else going on that, between the parents, just something else going on here, Judge. I just don't think there's much evidence that there's a move is necessary. And in addition to that, there's the concerns about the history of abuse in the paternal grandmother's home as well.
All right, Mr. Buck, thank you. Ms. Genstl.
Thank you, Judge. Well, we heard unrebutted testimony by the case manager that maternal grandmother has given her reason on a couple of different occasions not to trust her. That's the same maternal grandmother that's currently responsible for supervising her own daughter's access to the children that are placed with maternal grandmother at this time. And I think a reasonable reasonable person and certainly a reasonable fact finder could find that looking at those incidents together, it appears that maternal grandmother is covering for her daughter. And I think that's a concern. CPS, in their motion for placement that they filed on April 29th, it cites to dad's progress with his services as a reason for filing the motion for placement. That was a reason they said they were seeking a change of placement for KK, is that dad had made due to the father's progress. But they haven't done a return home staffing for dad for KK. CASA's not even here, right? So we don't know if CASA has visited, but Ms. Halford, the caseworker, said she hasn't visited dad's new home. And I understand that he's only been in that home for about a week, so I'm certainly not faulting the network. I don't understand why dad isn't being considered for placement with this child, particularly given the fact that CPS in another county placed a 5-year-old with him after mom went to jail. I think that may be an argument for another day. I would ask the court to order CASA and the network to go visit dad's house and see if there are any concerns. And then that way I can file a motion for monitored return and ask to come back on another hearing for that. All of this just happened kind of contemporaneously. And so I don't think anyone has the evidence that they need at this time to address the issue of placing KK with dad. So obviously dad's second choice would be to change placement to be with his mom, paternal grandmother. Thank you.
All right, Ms. Kensel, thank you, Mr. Keating.
Thank you, Your Honor. I just received some information that I was not made aware of before this hearing or even before the motion was filed. I think first, let me address Ms. Kunsel's points, which I think are well-founded, but I think it's a little early to consider a placement with the father. He's just really started getting after it, and I don't think that we have enough demonstration. I know that's a fabulous word.
Mr. Keating, my
Yes.
apologies. I believe Mr. Buck just dropped off.
Well, he did. We'll wait.
We'll give him a moment.
All right. Are you back, Mr. Buck?
Yes, I am. Don't let me stop you guys. Keep going.
Okay, good. So do I need to repeat anything?
I don't have a chance to respond anyway, so I don't think there would be any.
Okay, not a problem. But Your Honor, I think what I would like to urge the court to do right now is continue the placement with Ms. Smith on a temporary basis until I've had a chance to visit the home. I have not had a chance to visit. It's my understanding that there is an older young man there, a 19-year-old, that I need to go do some visitation with and make some recommendations to the court. So that would be my request, Judge.
All right. Thank you, Mr. Keating. Ms. Whitewood.
I don't really have a recommendation. This isn't my child. I have been in both homes, and I do not share the same concern that the network has with the maternal grandmother's home at all. But again, I don't have a recommendation.
Ms. Whitewood, thank you. And Ms. Walker, back to you.
I have nothing further, Your Honor.
Okay. All right. Okay. All right. Thank you. All right. Let me begin by saying clearly, this is not about bare feet and plywood floors. This case, to be sure, was on a very different trajectory not too long ago. And but for mother's relapse, we might very well expect to be in the middle of a monitored return to her. Be that as it may, the court has concerns with the admixture of the older children and their needs, and the 2-year-old KK. Not just their truancy, though given their respective truancies, they can't be doing anything productive and salutary when they're not in school, save and except dividing or taking the maternal grandmother's energy and attention away from KK. Nor is this a competition between grandmothers. I'm so grateful for both of them. Thank goodness for both of them. I don't even want to countenance where we would be without them in this case. We know where we might very well be. And I believe they took a very strong, very necessary, and quite frankly, an instructive step when they made mother leave almost instanter subsequent to her drug test back in February. So it's not that they are not a safe place for the children who are there. Now, frankly, the hearing was long on being conclusory and short on evidence. However, the standard of proof is quite low, and the risk is quite high. Safety is all of our paramount concern, and we always need to be, especially when there's so many moving parts in these cases and such long-standing, if not deep-seated issues and needs, we have to be all about concurrent planning. So to that end, I'm ordering the Texas Family Care Network to perform and complete within the next 2 weeks a reunification assessment on the father, Troy Smith. Now, further, the court is going to continue to take the department's motion under advisement. I'm neither granting nor denying the motion. It might seem to be kicking the can down the road, but that's really not what's going on beneath the surface. I am going to hereby continue the extended visit with Ms. Smith until agreement one way or the other, or further order of the court. You all know that we have trial on June the 25th at 9 a.m. Our dismissal is July the 14th, 2025. So do you all have mediation scheduled yet?
Yes, Your Honor, we do.
And when is that?
The 20th, I do believe, Judge, the same day I'm in court in Angelina.
Okay.
We need a protective order for Mr. Keating to come to mediation, please, sir.
I'm going to do it by Zoom in Angelina. So you may have to stand in for me for a little while, Amy. I am more than confident that you can do that.
All right. Well, I'm not. Then I wish you all well at mediation, and we'll certainly navigate that time conflict. All right. So parents, remember, and I do want to say, Mom, Ms. Chandler, I'm very proud of how you've handled this of late.
Yes, sir.
But I think you know how to do this. Okay.
Yes, sir.
I think you know how to do this. And these relapses arguably are part of recovery, but they really need to become farther and fewer between and eventually just dry up. You'll always have recovery. That's fine. Okay. So keep doing what you're doing and not doing what you're not doing, but you're going to have to, I think, find something else other than just staying busy. Okay. And just working, 7 days a week. So don't. So remember, I told you a long time ago, don't tell me, show me. Okay. So you keep increasingly taking better care of your children's mother. They need you. They want you. They love you and they deserve you. Fierce. Right? So
What about visitation
get that mask on yourself, and then you can tend to them. All right. I don't want your visitation to be to become less. I don't know how we can. It needs to be supervised, and unless and until you and I both know that meth will get out of your system roughly, generally, in 3 days. So it's going to need to be PPEs full, at least visiting with KK.
Yes, sir.
Until we are free and clear of any methamphetamines. Those levels have to go down precipitously and fast. As possible, as fast as possible, given one's metabolism. So, I want the mom, Ms. Young, Ms. Hafford, to be visiting, and I know there's a distance between, obviously Woodville and Highlands, but you all work that out, and I want mom visiting at least weekly, and at least for 2 hours weekly. So, and and if we can put up some, I wouldn't object if you all could arrange this to where, even the maternal grandmother could still supervise with the right safeguards in place, as long as the concerns are recent and so serious. But I'm going to defer that to you all.
Okay.
I think you all can do better at that. And by you all, I mean, the attorneys in the network, and CASA. Okay. So I don't know why CASA was not here today.
I believe she may have become sick. She talked to Jasmine yesterday and she wasn't feeling well.
Okay.
So something may have come up.
Okay. Well, I hope she's feeling better, much better. But I don't think it would have changed my opinion, but I certainly need to hear from them. So, in a sense, the attorneys for the children were, in a sense, wearing two hats today. So that's the ruling of the court. The court finds that it's in the best interest of the child, KK, subject of this hearing. So anything else from anyone else?
I have one question, Your Honor.
Okay, and don't let me forget to admonish the parents if I haven't already. So yes, please.
Regarding the oldest child, she is closer to 18 than 17. She can legally be a parent or go to prison. Can she just visit with her mother as she chooses? I mean, she's
I think I've said yes to that before, and it's still a yes. Okay. Yeah, it's still a yes. She's a grown woman.
And she's been saying that for at least 5 years now.
Well, I'm making no finding how long she's been that.
Right.
But yes, and I yes.
Thank you. Yeah, it's just common sense, so I appreciate it. And okay. She does too.
And the point is, it does not have to be supervised. Yes. And it can be as frequent as I can't even say ALS, because we have several of those, but as frequent as the oldest ones.
Judge, I have another court calling me to get started on a trial. Would it be acceptable since you've made your ruling, may I be excused?
You may, Mr. Buck. In fact, we're going to excuse everyone. So my apologies to whomever that might be, Judge Tucker or whomever.
Judge James. So.
Judge James. Yes, my apologies. We can
Thank
share.
you.
So, all right. So you're excused, Mr. Buck. Everybody's excused. Thank you all very, very much. Please take care. Admonishment. Yes, Mr. Buck. All right, Mom and Dad, remember that if at the end of this case, if you're not willing and able to provide a safe environment for your children, your parental rights may be further restricted or even terminated permanently. I know you both understand it. I know that neither one of you wants that to happen. So keep doing what you're doing and not doing what you're not doing. Work your services and do the all-important demonstrate. All right, so we'll see you all back 6:25, 9 a.m. final trial. Good luck in mediation. We'll see many of you Friday in Jasper County. Please take care.
Thank you, Judge. Thank you.
Thank you.